Order. This is the start of a new inquiry for the Northern Ireland Affairs Select Committee and on the government's new approach to addressing the legacy of the past in Northern Ireland. I'd like to invite any members if they have anything to declare. No? Thank you very much. So, Daniel Holder, Alyson, Kilpatrick and Anna Bryson, welcome. Could you say who you are and what your role is, Daniel?
Thank you, Chair. I'm Daniel Holder. I'm the Director of the Committee on the Administration of Justice, CAJ, a Belfast-based human rights NGO that has been long immersed in the detail of legacy, including our most recent report in December of last year, November it was of last year, which related to the question of the viability of root and branch reform of the ACRAR.
Alyson.
I'm the Chief Commissioner of the Northern Ireland Human Rights Commission, set up pursuant to the Belfast Good Friday Agreement and the Northern Ireland Act. I should add that prior to that, I think relevant to the work of this committee, I was Human Rights Advisor to the Policing Board for a number of years, and I'm also the independent expert that's referenced, I noticed in the PSNI's evidence to you, who carried out the review of Canova.
Anna.
Hello, I'm Anna Bryson. I'm a Professor and Director of Research in the School of Law at Queen's University Belfast. I'm here to speak to written evidence that was submitted jointly by myself and my colleague Professor Louise Mallender, also of Queen's Law School and the Mitchell Institute.
Thank you very much. What's your view on the current government's approach to legacy thus far, Daniel?
Well, things have begun to move, but they've moved very slowly. A lot of, things like legacy inquests could have been opened a lot earlier. The commitment to repeal could have been taken forward a lot earlier, and we're only really at a stage now where we're looking at potential measures on reforming the ACRAR. We're quite concerned at some of the appeals, for example, that particularly, and I'm sure we'll get into this, the revival of the notion that there should be some sort of system of pseudo-inquests, some sort of exceptionalist system of essentially second-class inquests outside the framework of the inquest system. But I suppose and Lord Kane rightly recently said that the vast bulk of the Legacy Act essentially is the ACRAR. If you look at the whole framing of it, I mean, the amnesty has now gone, and the framing of the ACRAR was very much around the amnesty. But the purpose of the Legacy Act really was to replace the proper investigations that were taking place under the package of measures with ACRAR reviews. And our concern is obviously what's happening there is replacing proper and thorough investigations with much more light touch reviews. And in terms of the outworkings of our own report, we don't think things have moved on since the Council of Europe's assessment that the support for the ACRAR was minimal among families. We regularly hear the concerns of families that the ACRAR is essentially a cover-up commission, yet, and I think they've good reason for those concerns, yet there has been a unilateral decision to retain it. Nevertheless, both the Irish government and ourselves have looked at the question of reform, and our conclusion has been that really only some sort of clean break, given not just the toxicity of the relationship between the ACRAR and the Legacy Act, but also its conduct since it's been set up, only some sort of clean break where you have a substantive and meaningful root and branch reform person that produces an entirely distinct institution to the ACRAR, something with a different name, different legal framework, and different leadership, something unrecognisable to what's presently in place. That's the only thing that's going to render a reformed legacy institution viable in terms of both human rights compliance and in terms of the important fact of building confidence with families. But I probably want to stress that's doable. That is eminently doable. I mean, in terms of fixing the legal framework, and whilst the legal framework in itself is insufficient, it needs a lot more than that. It needs a changed composition and leadership. But a lot of the work was done in terms of fixing the legal framework during the Stormont House negotiations as to what a potential blueprint could be, and also we have the benefit of the learning from Operation Canova. So at some, look, we welcome that there is a change of approach, but there has been a unilateral decision to retain this institution. And I know There was a rush to set it up before there was a change of government. A lot of money was poured into it. £250 million has been committed to this institution that currently has, I think, currently has 24 cases or 18 individual investigations relating to 24 individual families, which is a sort of tiny number. Yet we think things could have moved a lot more quickly at this stage. However, there is very much a different approach, and there is at least a level of engagement taking place.
Thanks. Alyson?
Certainly we welcome the new approach. An awful lot more time and effort has gone on into engagement, certainly with the Human Rights Commission. Quantity and quality of that engagement has improved enormously. So we are meeting, we are hearing what is being considered. Since I first spoke to this committee, I think we've met certainly on 3 occasions. And very recently I had quite a fulsome update on where the thinking was. However, I do also agree with Daniel, it has been very slow, it's very piecemeal, and we're still unclear what the end goal really is. We say it doesn't go far enough, and we've said that in our written paper. It has not, and is not likely now, I think, and I'm talking now about the ICRIR, and that's one of the things that sort of seems to be off the table for discussion. And that was taken off the table before, I think, families, who are the ones who are supposed to be most concerned about here, before they had an opportunity really to be consulted on it. So there's one thing seems to be settled, and that's the ICRIR, about which we have some concerns. Everything else is up for discussion, which we absolutely welcome. But I don't think the ICR is going to gain trust and confidence. It hasn't. In the short period of time, well, that's a rather long period of time now, it's over a year that it's been in existence. The numbers are minute compared to the cases and incidents that need to be dealt with. And that's despite the fact that there is nowhere else for these families to go. So everything has been shut down for a year. There's nowhere else to go, but ICRIR, and still very small numbers are coming forward. So if we're serious about this, and I know this government is serious about it, and I believe what I'm being told about that. If we're serious about it, then we need to ask why. Why on earth? And tinkering around the edges is just not going to change that. I would also query, I think, whether the approach is sufficiently cognizant of the actual, what is sought to be achieved, what's the purpose of the Act. If it's reconciliation, and I have no reason to doubt when I'm told that that is what it is believed this will achieve, but I'm not told whom is supposed to be reconciled by the Act. Where is the reconciliation coming from? Is it between families? Is it between the state and families? Is it society more generally? Is it between the army, the police and the state, etc.? And unless that's clear and somebody sits down and thinks, these are who we're trying to reconcile, this is what we're trying to do, this is why we're trying to do it, this is why it's going to work. And in doing that, they need to listen to people like Bryson, they need to listen to the families. Then the whole thing has started from a false premise that somehow forgetting about what happened before is going to make people forget their fears and distrust of each other and of the state. And the other point I think I would make, which is often forgotten, and this is just why it's so much, the fundamental principles are so more important than the tweaking around the edges here. What has happened, whether it was the intention or not, but what has happened is that one of the alleged perpetrators, and in many of these incidents, in cases, in inquests, in police ombudsman investigations, the actual suspects are arms of the state. And what has happened is that the state has been enabled to close down all those investigations into itself. This is not a truth commission in the way we might have understood it somewhere else in the world, where you're reconciling simply two communities. That is a huge step away from human rights principles. It's a huge step away from the ECHR in Article 2. I'm not saying that that's not possible, that something very constructive could be found here, but it's certainly not going to be found, and it's not going to be lawful unless there's a very real justification and legitimate aim. And that is also achieved lawfully. And I just can't, as hard as I would like to be able to be constructive and say that I think the ICRIR can be maintained and enhanced and tweaked around the edges, I don't foresee a way in which it's going to end up being able to lawfully discharge the obligations. And the very last thing I would say is, sorry, I'm speaking probably too much for the question. The very last thing I would say is, even if we as the Human Rights Commission doing our job could say, this is compliant with human rights as standards as we know them, or this now complies with the Court of Appeal, which was a limited analysis of this situation. But what you still have to go back to is this going to do what it's supposed to do, which is reconcile? Because if not, why touch it? Why bother? Why upset and cause distress? And through the Policing Board, then on Operation Canova, now at the Human Rights Commission, I've met so many of these families. They're not belligerent. They have reconciled. They reconciled following the Good Friday Agreement. They've taken on so much reconciliation, and they're saying this isn't going to help. This is just going to hinder. So if its fundamental premise is gone and it's unlawful under the Human Rights Act, then I do wonder how we can tweak it and how you can actually achieve something. So I'll stop there. That's probably probably too much.
That's fine. I mean, I'm going to bring Simon in a minute, but just before that, I mean, reconciliation should be for all, and I think that you do you really believe that the government's outlined approach is clear enough at this stage to meet the needs of victims? I mean, I think you've answered the question there really, but what does it need to do? How do we move on?
I think a very honest question needs to be asked. What is it trying to do here? It's not enough to say reconciliation is a good thing to try and achieve. What is it that we're trying to reconcile here that wasn't done 25 years ago or has been being worked on for years and years and years while these cases have been going through the traditional system? That's one thing I would ask. We can't start just assuming that reconciliation of this nature is required and therefore we find some way to work it. What I would also say, lastly, my colleague here is an international expert on the notion of reconciliation, what it takes. But when this started off, and we can't forget how this started off because this is what a lot of families and members of Northern Ireland society remember how it started off. It was said expressly to be to protect veterans. It became about reconciliation after the event is how it's understood, and I think there's some justification for saying that. It's very difficult to then say the thing that was set up to protect veterans, we can tweak it a bit because it's not really about that, it's actually about reconciliation.
Okay, Simon.
Ms. Kilpatrick, and indeed Mr. Holder, I'm not entirely sure it's fair or justifiable to, in one breath, welcome a greater degree of engagement from the government in the evolution of its plans and consultation, and then chastise it for not moving quickly enough. You can praise them for one, but don't damn them for the other, is more an observation. But could it just be on the take-up of engagement with the ICRIR that we've had a general election, the Labour Party was clearly going to win that general election. They had made very clear their opposition to the Legacy Act and their commitment to change it. Could that be the explanation, hitherto unnoted in answers, to that very low and arguably disappointing take-up, that a long-standing problem facing another period of change and fluidity, why would people necessarily engage proactively and fulsomely with something if they thought that in pretty short order it might be superseded by something else, replaced by something else, its terms of reference altered, making working hand redundant?
Can I start with the length of engagement? It is, I would respectfully suggest, entirely possible to have good quality engagement, but for it to take far too long, and also for everything to be subject to engagement when some things are absolutely clear and could have been done straight away after the Court of Appeal judgment, for example. Not everything in the remedial order addresses what's in the Court of Appeal judgment, so there's no need to engage on that. In terms of the reluctance to sign up to ICRIR, that's not, I don't know where, that may be a speculation. I don't know where that comes from because I certainly haven't heard that. No one has suggested, either in the evidence or even I think the ICRIR themselves, that people are not engaging for that reason.
But it could be.
It could be for, well, it could be for any number of reasons, but what we have is the evidence. So the evidence so far from families, and you've heard from some of them in the past, even from the police, the reason they're not engaging is because they don't trust it. So nothing has changed. They haven't begun to trust it and started to join in numbers. And I don't think it's simply that people are waiting to see if anything better happens. And what I would also say is that what families have said, and you will have heard this yourself, but it is sometimes used against them. They are getting old, they're getting desperate. They desperately want something to work. If they had any hope in this at all, I think they would have signed up already. They don't want to wait any longer, because every day they wait is like torture to them. And many of these people have died. Some of the people I met, Policing Board and also Canova, have since died. So they aren't trying to string this out waiting for something different. That's all I would say about that. That's Danielle?
Yeah, just on the engagement point, I totally agree. I mean, the remedial order, when it was passed, it made a finding of incompatibility, that the ban on inquests in the Legacy Act is incompatible with the ECHR. Government's remedial order back in September could therefore have reinstated inquests rather than waiting this way. I'll give inquests an example of engagement. I mean, the Secretary of State himself has been very proactive in engaging. He's met with ourselves, he's met with other groups, he's met with families. I've witnessed him meeting with inquest families where he's been very personable, very empathetic, has listened to families and their experiences. But at the end of the day after that has then done the precise opposite of what every single family asked in the inquest system. Every single family said, we do not want to be sent to the ACRAR. They understand the agenda behind it and what it's been set up to do. We're also in a situation where coroners had said that the ACRAR wasn't the appropriate mechanism to substitute inquests, and indeed the Court of Appeal has found that the ACRAR cannot lawfully conduct investigations into cases that were within the inquest system. Yet the Secretary of State, after those meetings, took the decision to direct families to the ACRAR rather than simply reopening inquests. So I think that's the frustration around engagement. And one plea on engagement is victims cannot be gaslighted anymore. The ACRAR has been re-traumatising enough. Having inquests being taken off them has been traumatising enough. There were a number of occasions under the last government where very significant changes were promised to the Legacy Act. I think the phrase game-changing amendments was used on a number of occasions. Both the UN High Commissioner and Council of Europe Committee were very critical that those amendments, when they did come, came at the very last minute, so they couldn't be scrutinised. But when they were scrutinised, it was very clear that they certainly were not game-changing. A lot of them were window dressing, and some of them actually made the legislation worse. And I think that's a real warning at the minute, when I think we are going to move into a more formal stage of consultation where the new government will put out proposals, and it's very, very important that there's not a claim that amendments are far-reaching and radical if they are not, because we are all going to notice. And families are going to notice, and they're going to realise what is needed is very significant reforms, and that'll be called out. In terms of the issue, why people aren't going to the ACRAR, I think families are not fooled by the sort of suggestion that this is just like a sort of historical investigations unit, this is just like an independent investigations unit as was envisaged under the historical investigations unit. The international community hasn't been fooled either. The UN Human Rights Committee itself in Geneva last year called out the weakness of the ACRAR's review function, called for it to be replaced by proper mechanisms. And the notion that the ACRAR conducts proper thorough investigations, it's very clear that's not what the architects of the ACRAR set it up to do. And they set its legal framework and appointed all the people who run it. That's even clearer since we've had the court rulings. If you look at the ministerial papers that were released in Dillon in the Court of Appeal, they demonstrate that the express reason for the option that was put before ministers of either continuing with the package of measures or adopting the Stormont House Agreement was expressly rejected on the grounds that it would continue proper investigations, specifically to veterans, but obviously if you cancel some investigations, you cancel all of them. And instead, this sort of light touch model review is going to be brought in.
Can I pause you there? Sorry, sure. Daniel. We will be coming on to this in the next question, but I just wanted to go back to my original question about the government to Anna, if that's okay, Anna.
Yeah, no, sure. I mean, I think one of the problems is that hopes were raised with the bold statement that this government was going to replace and repeal the Legacy Act. And I think, as you've heard from Alyson and from Daniel, I think what we have seen since is a deep-seated frustration on the part of victims who are now left somewhere in limbo. And following on to the question raised by Mr. Hoare, I do think that it is very important, as Daniel said, to note just how legally literate and savvy the victims in Northern Ireland are, not least because they have been carrying the weight of all of this for years, trying as best they can to get answers. They well understand the detail of what is on offer at the ICRIR, and they have, having listened to them, have very considered and well thought through views as to why. And they have, I chaired an event only a matter of months ago. There were literally hundreds of victims in the audience. The session that I chaired had 4 families speaking, as Alyson said, to the pain that they've been carrying for decades. And I never cease to be humbled just by how well they understand, but how clear they were about their reasons for their decision not to engage with ICRIR. So what I would say on a more positive note is that I do think, Chair, that the manner in which this committee is approaching this inquiry is really to be welcomed, not least because I think in a number of key respects you've broadened out the questions to the fundamental issues touched on by Alyson, asking what we understand by reconciliation, because ICRIR has said that is its North Star, that will guide and inform everything that it does. It has also said it will inform the prioritisation of cases. So it's clearly extremely important for us to stop and ponder what that actually means, and to try and understand how they understand it, but also how that stacks up when we look to how reconciliation has been understood and, insofar as it has been implemented in other countries, how that has unfolded, but also to look at how, as you saw in our written evidence, how international courts and human rights treaty bodies have understood reconciliation. Because again, the Commissioner has said very clearly he wants to have a rights-based reconciliation. So we clearly need to look at that relationship between rights and reconciliation. And as I said, I welcome the manner in which this inquiry is opening up those broader issues. And I know we'll come on to it later, but I saw that also in the approach to Part 4 of the Act, the work in oral history memorialisation. You seem to have taken a broader approach to that, to take a step back and say, no, well, what is the role of historians and what would a historical approach, how might that help? So I welcome that.
Thank you. Liam.
Thank you very much, all of you, for your answers, and I think some of you touched on some of the bits that I'm going to ask now. This is to all of you, but Anna, if you want to go first this time. Just specifically, I know you've sent written evidence already, but just for the committee, do you believe the government's current process of consultation on specific measures to be included in primary legislation is adequate?
I mean, you touch on an incredibly important issue, Leah, because I just mentioned about, how you could have a human rights compliant approach to reconciliation, and front and centre of that is the degree to which it is inclusive of victim perspectives. They must be consulted at both the design stage and the implementation stage. So I guess a key question then is to what extent victims were consulted. And the issue really comes back to ICRIR, because whilst, as has been noted, there is an uptake in the pace of engagement and consultation, the fundamental issue here is that victims were not directly consulted on whether or not to retain ICRIR. And Paul Gallagher, for example, who spent most of his adult life in a wheelchair, and who's a trauma consultant with WAVE, was very clear in stating the manner in which it rubbed salt into the wounds to be asked for to be consulted after that core and key decision had already been taken was a fait accompli. So I think in that sense, the other way in which I suppose we might look to the extent to which victims are included is in the level of engagement, and as has been noted in terms of the level of cases, the number of families coming forward to seek answers is very low indeed. So that is a deep cause for concern.
Alyson, would you like to?
Yes, I would endorse that entirely. Consultation is not talking, it's not sharing information, it's allowing people to actually influence the outcome. And if the outcome is predetermined, it leaves people, even if it's not, feeling that the consultation attempt is disingenuous. and it's not going to lead to any, it's not going to influence anything. And one of the singular decisions about the ICRIR, which is supposed to be there instead of all of the package of measures that the McCarr cases that went through courts for decades, that was decided upon, and even after consultation we're told, well, that's staying. We're not really listening to anything you say about that. I think that's very disappointing, and what it does is make trust and confidence even further away. It just pushes people further away. And they say this is so difficult to talk about. I'm going to have to talk about it again, just to be told again that core thing that I object to, that's not changing.
Yeah, I mean, I think things, again, to reiterate, could have moved a lot more quickly. I mean, when the new government took up power, it could have quite quickly repealed the Legacy Act, and that would not have left a void or vacuum. It simply would have returned us to the election was in July of 2024. It would have returned us to the de facto and de jure situation that existed on the 1st of May with the package of measures, with all of the existing mechanisms, inquests, police ombudsman investigations, PSNI investigations at a time they were most delivering for families. In terms of where we are now, we've had engagement by the Secretary of State, engagement by officials, but it really needs to move into a more formal stage where proposals are put in writing and a formal consultation document is produced. So, as with all of these things, the devil will be in the detail of what is actually on the table. So I think that's the stage we're now at.
Thank you very much. And just if there anything you want to add, and again you have touched on this slightly, but how in the ways in which that could be improved. I know, Daniel, you just said something formal specifically, but is there anything further you want to add in terms of how this can be improved?
I mean, let's not forget we did have an enormous consultation, formal proper exercise on the Stormont House Agreement, of which there were well over, I mean, there are thousands and thousands of responses, clearly indicating support for that approach. And that essentially is the existing agreement that sits there. This is an agreement between the UK and Ireland, including a treaty on one of the mechanisms that was completed and then was torn up and unilaterally torn up in 2020. So there's a lot of consultation that is already being done. I think we're really at the stage now of seeing reform has been promised and committed to, and repeal has been promised and committed to. What's that going to look like in legislation?
Alyson, do you have anything to add?
No, I think I can only agree with that. There has been years of consultation, an agreement was reached. New Decade, New Approach said 100 days, we're going to put this in place. Everyone had reconciled with that, was looking forward to it. I'm not sure what further consultation will do now. Certainly, as far as the victims and families are concerned, the vast majority are going to tell you what they've been saying for the last year and a half.
Anna, did you have anything you wanted to bring in there on how you think it could be improved?
I mean, I agree with what has been said. There's consulting and there's listening. So victims have said loud and clear, 17,000 of them in response to the former public consultation on the Stormont House Agreement bill. They have made their views and indeed many of their concerns have been endorsed in the courts and by international human rights bodies. It's time to listen.
Thank you. Claire Hannah.
Thank you very much. Alyson, can I start with you? In your evidence, you say that reinstating inquests could and should have been done by remedial order. Why do you think that wasn't done, and what would be the most appropriate way to address that now?
I'm not going to put myself in somebody else's head why it wasn't done immediately, but what we now see is that there's an intention to move towards to not reinstating inquests actually, but to putting a lot of what would have been inquests into the enhanced inquisitorial procedures of the ICRIR. So maybe at the time it wasn't intended that what it really meant was just that inquests were back. We've got inquests again, and those inquests that were stalled or weren't allocated would proceed. And I think that's really all that needs to happen. I know it sounds simple me saying it, but that is a simple thing to do, because we had inquests until they were stopped by this Act. So if you want to reinstate inquests, just stop the Act stopping inquests.
And do you think that the enhanced inquisitorial process can get the same level of information and accountability as the current inquest or the sort of previous inquest system could?
I don't. I don't, having seen how inquests work over many years, having been party to some of them, I've looked at what's required in, for example, Canova cases. What is it that gets to the information? And this sort of enhanced inquisitorial procedure, which is set up at the minute, it's not even statutory. It's not even a statutory process. I don't see that it has all the powers that a coroner would have, but in any event, it has nothing more compelling than a coroner would have had. But it seems to be, these enhanced proceedings seem to be being put forward as something that's going to get more truth, more answers, and somehow overcome the problems with disclosure. But no court has managed to do that yet. No coroner's managed to do that yet. And these proceedings don't have anything that they didn't, because it's not about it's not having the power to ask for information. It's getting it. And that's a wholly different thing. What do you do when MI5, for example, or the police, or security forces, or paramilitaries refuse to hand over information? Where do you go? So Declan Morgan and his team can't go anywhere that other people couldn't.
And we'll come back on to some of the disclosure and vetoes, but I suppose that upstream addressing of those. Daniel, you're indicating, I think, the same. That
we're really, really concerned about this model of what we've called, and ourselves and other human rights groups, sort of pseudo-inquests, the enhanced inquisitorial procedure. And we're not just concerned about it in legacy cases at the minute. We've made a more detailed submission on this to the Joint Committee on Human Rights, as have Justice and Amnesty and other NGOs, because the concern is that if a sort of essentially an exceptionalist second-class inquest system is set up for one group of people, then that sets a very risky precedent that could, in the future, mission creep into other areas of the justice system. I mean, the enhanced inquisitorial procedure, what we're calling pseudo-inquests, was something put together by the ACRAR internally, by Declan Morgan internally, to arguing it could emulate the standards in inquests. Now, we were always very sceptical of that. I mean, if you just think through the various elements, it's meant to emulate inquests, but there's no court, there's no independent judge, families don't have access to their own lawyers, they don't have the same rights of disclosure, and the executive branch of government can actually rewrite the judgment. That's absolutely nothing like an inquest. The vast majority of inquests are working very, very well, delivering verdicts, getting through the procedures, despite the sort of delays in disclosure and things like that. There's a tiny number that have been derailed by the withholding of sensitive information, but the vast majority can simply proceed. The tiny number is 5, and I should declare we act on one of them, Thompson, that's been appealed up to the Supreme Court. And I think with that particular issue, disclosure and inquests, the last thing, I think it is tied into having some level of national security veto control. And in terms of other evidence that this committee's perceived, I was very taken and had heard it before, the annex to the PSNI's submission, which is a speech given by Chief Constable John Boucher to the British Irish Association conference on this issue. And I think what he emphasises there is very, very important. We need less secrecy, not more secrecy, in legacy processes. Far too much is overclassified, and I think that bringing this sort of pseudo-inquest system in is really about that sort of approach to information control, but it sets such a dangerous precedent for the UK in so many areas.
And obviously none of the elements can work independently, and we need to get a complete picture. Are there, based on the model bill team and the previous analysis, are there any amendments to an order that could make a process like that fit for purpose? And then additionally, there's obviously the narrative that more inquests and more exploration is injurious to reconciliation. How do you counter that?
Yeah, I mean, I think I would go back in a general sense, Claire, to the point that Alyson made about tinkering around different, clauses and so on, is really not going to cut it if the fundamentals are so there's so many fundamental flaws there that victims do not have the trust to kind of buy in. So I mean, speaking to what you touched on towards the end there about broadening it out to speak to reconciliation, I would just again really fear that if people do not kind of trust the fundamentals of what's on offer here, it's very difficult to see how you can broaden out to meet the various requirements of what we would refer to as thicker reconciliation. I mean, I'm not a lawyer, so I'm not speaking to the very detailed clauses. I'm a historian, so my brain tends to think to that broader context and the other things that need to be put in place. But for me, it's a case of sequencing. If you don't get the right to truth through independent and effective investigations right, then what really saddens me is that it's impossible to then get to the incredibly important work that needs to take place at a later stage around broadening this out to look at the way in which, you know, various different layers in society have been affected and have been harmed, to give them voice, to recognise gender-based harms, sexual violence, all of the deep and layered themes of our conflict, because all of that work has to happen if we are to advance towards, I suppose, the type of sustained reconciliation that we all aspire to. So, I mean, the short answer is that tinkering around a clause here and there is not for the reasons Daniel outlined, but also for the broader reasons I think is unlikely to solve the problem.
Thank you, Chair.
May I add just what I should have said in relation to what the Court of Appeal has already said? So the Court of Appeal did hear from senior counsel on behalf of ICRIR who were interveners. They're given permission to intervene, and they talked about all the procedures they'd put together themselves or could put together themselves. The Court of Appeal said two things. Firstly, however well intentioned you are, that's not good enough. The law is the law and it has to be set down, and whoever takes over ICRIR should be bound by the same law. It said next of kin involvement was inadequate, that the rules on disclosure were inadequate. What I would say is, why should some inquests be different? What is it? What's the difference here? If these are just as good, if not better, why not apply this to all inquests? So there's something different here. So let's be honest about it and say these are different. So why are they different? Instead of pretending that they're just the same, and if anything, they might be a little bit better. But if your loved one died outside of the Troubles, you're not going to get one of these better ones. So sorry, I don't mean to be flippant, but it really gets to the heart of why people are questioning this. And the last thing, inquests injurious to reconciliation and more cases. And I know, and some people genuinely believe that to be the case, and I'm not saying they're wrong. Maybe I'm wrong in this. But there is no evidence that suggests that. Quite the opposite. And if you read John Boucher's speech, he talked about when he took over Canova, what was injuring reconciliation and injuring trust was the failure to have these cases heard, not hearing them. He came out with some appalling findings in his just in his interim report. That helped. That did not hinder. What hindered was the few cases that he dealt with where he couldn't get the information, or when he closed his interim investigation, security service came up with information which they hadn't given to him before. That's what hurt.
Thank you. Thank you, Chair.
Thank you. Al Pinkerton.
Well, thank you all very much, and please forgive this question because it will sound repetitive, because I think you've all spoken very clearly on the subject already, but there is a value for us and for this inquiry to have your answers contained under particular questions. So my question is, can the government build trust in the ICRIR? And I know, Daniel, you've already given a very clear explanation why, in terms of the origin story, and institutionally and organisationally, I suspect you're going to say a particular answer. And Alyson, I think you've spoken very passionately about why philosophically, in terms of the understanding of the word reconciliation, that this organisation perhaps falls foul. And Anna, too, intellectually and historically, you've made a very clear case too. And cutting across everything that you've all said, there's the issue of public trust. So my question is, again, nonetheless, can the government build trust in the ICRIR? And I would be very happy if you wanted just to give a one-word answer.
I mean, a two-word answer would be there needs to be a clean break. There needs to be, as the conclusion of the report, there needs to be an entirely distinct institution to transform what is there into something that is actually viable. I'm happy to elaborate on the reasons as to why there's such concerns.
I would be very happy for you to do that.
So, I mean, if you look at the context of this, so the Legacy Act was deliberately done to shut down the package of measures at a time that it was most delivering for families. And why was that done? It was done because ministers in the then government, and they openly articulated this, did not like the outcomes of these mechanisms. They felt they were creating, quote unquote, a pernicious counter-narrative. that damaged what they saw as the official truth. So logic would have it as they're not going to shut down those mechanisms that were doing proper investigations just to replace them with another mechanism that does exactly the same types of investigations and comes up with the same outcomes. They were looking to create something that was very, very distinct. And we have the benefit of not just ministers' statements at the time, but also the papers that were declassified during the court's hearings. So if you look carefully at what ministers were saying, at least to some audiences, both within Conservative Party publications, but also to the House on a number of occasions, they expressly said that the purpose of the Act was to shut down investigations into veterans, that no longer veterans would have to fear essentially arrest and questioning powers, a knock on the door, etc., etc. That was said. They said that the legal framework then for the ACRAR appointed everyone who ran it, and in line with that sort of agenda. As I've said, the ministerial papers in Dillon expressly showed that the options of keeping the package of measures or implementing Stormont House, which the advice to the minister would be far more victim-centred and other things, were expressly rejected because they would have involved continued investigations. And instead at that stage, it wasn't called the ACRAR, it was the Family Report Body was the name it was given at that stage. It was very clear that what they wanted to do was something that was much more light touch reviews. When you look at the legislation, and I'll just go into two elements of it. So one element of it would be the investigation powers or review powers, because of course the word investigation was stripped out of the legislation and replaced with the word review, which normally means desktop review of papers. If you look at the investigation powers for the ACRAR and compare them to the Historical Investigations Unit in the draft Stormont House legislation, either the official or the unofficial model bill, the consensus that was reached at Stormont House is that you couldn't just trust an institution, you couldn't just give it discretion, because no one trusts an institution in that context. You needed to actually legally boilerplate when the threshold, the Bracknell threshold for an ECHR compliant investigation was reached, a duty on the institution to ensure that the investigation it conducted was thorough and compliant with the ECHR and with all the sort of codified standards that are within that. Every single bit of those safeguards was stripped out of the Legacy Act for the ACRAR. It was in the Stormont House legislation, but it was stripped out. Not only that, there were repeated attempts by non-government members of the House of Lords to put some of that stuff in, to put in that the ACRAR would have to follow either ECHR standards or even the minimum standards set out by Operation Canova. Each and every one of those amendments was rejected. So this late touch review framework could be put in. You even listen to the ACAR talking about how they take, so the Commissioner for Investigations telling the Executive Office Committee of the Northern Ireland Assembly how we take a very different approach. One of the examples we're given, we're going to focus on answering questions that families have of things around the sort of, well, what was the last words, the last experiences of a victim, etc. And of course, some families will want answers to those questions, but that's not a thorough investigation. The same happens with the provisions within the Legacy Act for ACRAR reports. Within the Stormont House legislation, it was recognised to prevent a lack of trust and to ensure proper outcomes for families and victims, that there had to be a codification of what would go into family reports, and that would have to involve maximum permissible disclosure to families about the findings of an investigation. All that stripped out of the Legacy Act for the ACAR. There's very, very limited discretion. I think they only have to sort of look into a death, and there's very minimal amounts apart from of minimum content that would go into family reports, which of course in the ACAR are subject to, and I'm sure we'll get on to this, the national security veto, the very thing that actually derailed the implementation of the Stormont House agreement. So the reason why there is no trust is because families know this is not the independent investigative body that they were promised at the time of Stormont House or existed under the package of measures. It's a very, very different creature, and they're right not to trust it. So the only way of building trust and restoring trust is to have a clean break from what is there and produce an institution that is very distinct to what is currently in place.
So taken as an institution, can the government build trust in this particular institution?
No, would be the one-word answer.
Thank you.
I can't stick to one word. I've never been able to, but I will keep it very brief because I'm going to concentrate on the practical independence required by Article 2 of the ECHR, applied directly by the Human Rights Act. We've talked about, and the courts have looked at structural independence, hierarchical independence, and the importance of both actual independence and demonstrable independence, and why it's critical, particularly where you have cases where the state may actually be a perpetrator in some of the investigations. The court hasn't really reached a view on practical independence of this ICRIR, and it said it will probably have to deal with it on a case-by-case basis. Now, that may be okay if the ICRIR was a unit of the police and only had one case to one case. This is everything is going to go through the ICRIR. What you have is two men with very distinguished careers, and I wouldn't suggest otherwise, who were appointed at a time when there was an amnesty in place. None of the amendments were even considered, let alone being put forward. The first senior appointment that was made by the Chief Commissioner was of a man, I say, very distinguished, and please don't take it any other way, but the fact of the matter is that he did not have practical independence for the purposes of any of these investigations. He was a very senior and well-respected serving officer with RUC and PSNI. That's no discredit to RUC or PSNI, but that is not what an absence of a practical conflict means. If you take Stormont House Agreement conflict of interest policy, if you take Canova conflict of interest policy and apply them to ICRIR, that team would not survive those conflict of interest policies, and I think that's a question that needs to be asked as well. Why is that? Why were those conflict of interest policies there for Canova, where they had no serving REC or PSNI officers, and it got trust in some of the worst cases you can possibly imagine, in multiple murders, including a state agent. And just practically, if you imagine the numbers that are going to be going through ICRIR, how on earth can we ask these families to take place in a queue after all they've been through, to get in front of a court to say, in this case, that chief investigator was actually trained police officer who we say killed my loved one. You know, you cannot extricate them. You can't add now more bodies that are somehow going to dilute it. So I think the answer is no, and I don't take any pleasure in saying that, because both men have had very distinguished careers, but the way it has happened, the way it's been set up, and decisions that have been made since, I'm afraid mean that there is not going to be confidence and trust, and that's not coming from me, but I can put it in human rights language, and I do not have the human rights language to dissuade people when they say they don't trust. I can't say it's okay according to human rights law either.
Thank you for your candor, Alyson. Anna.
I would just add, I suppose, in terms of, if I can speak to the academic language, trust is one of these, as you know, very complex terms. It's looked at in terms of interpersonal trust, institutional trust, organisational trust, analysed in terms of cognitive affective trust and so on. And it's notoriously difficult to measure. So we've had various different trust indexes over the years that have attempted to do so. Like reconciliation, it's much easier to pinpoint the instances of its absence. But we do know that when you have higher levels of trust, the capacity for individuals to negotiate, to cooperate and to compromise obviously increases. And I think, to come back to the kind of focus of your question as to whether or not that trust can be built. We have seen instances in the past where victims have trusted, Alyson alluded to Canova, and were engaged with in the right way and with rights in place and with independent mechanisms that they can have faith in. We have seen instances where trust can be built. It's not that we have irredentist, rejectionist victims who are unwilling to, risk their trust if the circumstances are right. But unfortunately, as you have been hearing, we have a context here where it is impossible for victims to place their precious trust, and trust that has now been dashed so many times in this particular institution. And as we've been saying as well, that trust linked to buy-in from victims is absolutely crucial. It's not just the academic literature that says that. International courts have said it, but even our own courts, Justice Colton said, reconciliation can only realistically be achieved with buy-in from those affected. So I think the point you raise about trust is fundamentally important, because all of the detail that we're talking about, you simply cannot move these mechanisms forward and advance reconciliation without that trust in place.
Thank you all very much. Chair, I'm going to pass back to you.
Okay, thank you. I've got a supplementary from Daniel Aldridge.
Hi, thank you. I'm just There's an element of confusion on my part, I think, because we're saying the ICRIR doesn't have trust. I think that's what's being said. But then there's also the other side of it, which is victims are getting older and victims are passing away. What I don't quite understand is we've got this ICRIR that's not working. It will take time and a lot of effort and a whole other process of gaining trust and engagement to establish something else. No? So, sorry, I'm not, so how do we square that? Because if ICRIR is not good enough, then, but to establish something new, why would we then think that would hold the trust of people? And how long is that going to take? And is that calculation good enough? Is that the better option than trying to stick with the existing?
I maybe just go first. The ICRIR, we need to remember, has only been there for a year. It was created. We had decades of cases going through the courts and becoming more and more successful, actually. The inquests were doing great work. Canova, as I say, was dealt with very successfully, police ombudsman investigation, gaining all that trust. It's not like the ICRIR was there for decades, and we're now saying, you need to... This was put in place and closed down every route to information that people had. And if you think about it this way, if you were to say, perhaps England, so an awful lot of unsolved murders, maybe they could do with something like this. It wouldn't be contemplated here at all. And I would say that, it's going to take a lot more time and maybe irreparable harm to let this drag on for a few years just to have the same outcome at the end. People who are affected by this, who must lead this, have said they just don't trust it, hard as they may. And the point about people are dying, the point about that is that the ICRIR, all that has done is extend time now. We're still arguing about the ICRIR and trying to get trust.
Going back to the inquest system.
There was nothing, in my view, there was nothing, it may be imperfect, but there was nothing wrong with what we had before. And I think, I know that sounds very trite, but we had something before. This is the new thing. This is the new toy.
That's really helpful to me.
And if there was going to be something else, because you really do want a different approach, then the Stormont House Agreement was the one thing that was agreed upon and I think would work.
Okay.
Only I can add, the remedial order will reopen civil proceedings. That's one avenue that families were really queuing up for, really had confidence in the courts. Inquests could be reopened very quickly, but in terms of the broader piece of an investigative body, just to stress again, the work was done. The legislation was drafted. There was a commitment in 2020 to implement it within 100 days. So the work of taking what is the ACR and transforming it into a genuinely independent historical investigations unit, the legislation is sitting there. It would not need to be prolonged. The barrier has always been political will rather than any sort of technical issue. The other institution, the sort of cross-border information recovery institution, is also already sitting there with its legislation and an enabling treaty. It could be done quite quickly if the political will was there.
Okay, great. Adam Georgie.
Thank you, Chair, and good morning. Thank you for your answers to date, and nice to see two of you again. Mr. Kilpatrick, nice to meet you. You've touched on this ever so slightly, Mr. Holder, but I wonder if you could give me an answer on this. The government is committed to considering previous provisions from the Stormont House Agreement. You just touched on that. Just for clarification, do you think that consideration could or should include separating investigative processes and truth-seeking processes? And I'll open that to all three of you.
That was the conclusion reached at the end of the Stormont House Agreement. It sort of frame it quite differently, and that on the one hand you have a body that can conduct independent police-type Article 2 compliant investigations in the Historical Investigations Unit. On the other hand, you have a separate body, which is the cross-border Independent Commission on Information Retrieval, which doesn't involve an amnesty, but follows the model of the Commission for the Disappeared, whereby people can go and give protected statements. But it's different to a sort of amnesty system in the sense that an Article 2 compliant investigation can still take place with another body. The only way that's going to work is if the two are successfully firewalled against each other, work in practice and work in law. So the idea that they can be done in the same body simply isn't the case. I have heard the argument of, well, are the two functions not combined within the ACIR's framework? I mean, they're clearly not. There's no provision for protected statements. It's not a cross-border body built up by immunities. It wasn't agreed by the Irish government, etc. There's all sorts of reasons why they're distinct. So I think the learning from Stormont House was to keep those two institutions distinct. We've said as well we'd advocate for a Stormont House Agreement Plus approach, whereby some of the gaps with the Historical Investigation Unit, just to flag two, is one is it couldn't deal with Article 3 violations, so very serious injuries, torture at the hands of state or non-state actors, punishment, beatings, etc., shootings, things like that. That could be extended. Also, we've also recommended a counterpart unit in the Republic of Ireland to deal with investigations there, and they would be historical investigation types units. The ICAR, not to be confused with the current body, the protected statements body, was always to be cross-border and international.
If an investigation is required as a matter of law, so if it is one of those cases that requires an Article 2 investigation because there hasn't yet been one, then that is precisely what's required. Truth-seeking, it depends what you mean by that. So truth-seeking, you can often get truth through investigations, and that's why Canova was successful. But it had to start off with the intention of being a proper investigation and using proper powers. Only then could you say there is no prospect of further evidence, no prospect of prosecution. However, we can now go down a different route and look at this from a sort of information recovery, truth-seeking perspective and have an independent report on it. But I don't see how the same people can be doing the same thing. And it's where the Historical Inquiries team actually got itself in some difficulty, and I think what made the Police Ombudsman's work quite confusing as well is in situations in Northern Ireland you have people who may be a witness, they may be a suspect, or you may even have somebody who is confessing to be a perpetrator linked to somebody else who may be a witness or a suspect in a different murder. You just can't. You need at the start to sit down and work out what is required here. Is it an investigation? That has to take precedent. Then look at all your other methods. But to think that the same people can be doing it, I think it's a disaster waiting to happen practically. And legally, it's not fulfilling your obligations because you're not starting off from the premise that an investigation may be required in certain cases where it's death or torture or serious injury.
I mean, I seem to remember with the lengthy negotiations around the Stormont House Agreement bill, there was a lot of conversation about the sequencing of the work of the ICIR and the HIU, and I think the sequencing point is incredibly important in terms of truth recovery and independent investigations. You need both effect. It is what we've kind of learned. For example, in Guatemala, there was a lot of disquiet about the fact that a Truth and Reconciliation Commission was seen as a way of drawing a line under the past without dealing with, independent investigations and so on. In broader work that I've been involved in around apologies, we've sometimes seen criticism of apologies that are used in an obfuscatory fashion to close down conversations, to create the illusion that we've dispensed with the past. And people are very, I think, alive to that. But it really speaks to this issue, this very delicate and challenging issue of the sequencing. But I think international best practice would point to the need, obviously, to uphold the rule of law by providing the independent and effective investigations required, but to also attend to the type of textured truth recovery that was provided for in the ICIR. And as Daniel said, that is not folded in to ICR's work.
Thank you.
Okay, thank you. Daniel Aldridge. Oh, sorry, Simon, I apologise.
Thank you. Thank you, Chair. I don't say this flippantly, but I always fear that we're in danger of discussing how to deal with the legacy of the Troubles, and the Troubles actually went on themselves. And that, I think, just points to some of the intractability of some of the issues at hand. Now, Ms. Kilpatrick, you said that nothing wrong with what we had before, in answer to an earlier question, and I've got some sympathy with that assessment. It was Herod who said, truth, what is that? Truth is defined by the person who's thinking what they say is the truth. Stormont House Agreement had many, many merits. The theory remains intact. But as we know, some of the parties in Northern Ireland withdrew their support, so one can try and flog a dead horse for as long as possible, but in essence, from a local political buy-in, if it's not dead, then it's certainly on a life support machine. Is there any merit in just sort of asking that sort of devil's advocate question, which is, there can be a perfect legal system which meets all of the international requirements and so on and so forth. But if it doesn't have buy-in and support from across the communities and other stakeholders, and I'm including veterans and military in that as well, then we do run the risk of just running round and round this racetrack forever and a day. And I just wonder whether there isn't any merit, and possibly some political bravery from the government, were it to turn around and say this is an intractable problem which has gone on for far too long. If there was a ready, easy solution, it would have been dealt with in the ensuing months after the Good Friday Belfast agreement. Let's now spend our time and our energies trying to shape a better present and future than dwell on the past. If evidence is there and the evidential thresholds are met, prosecutions, inquests held. Full stop, end of. No legacy act dealing with the legacy of the Troubles per se. Is there not some realpolitik bravery in taking that approach?
There may well be. I'm glad to say that's not a decision for me. What I can do is analyse what is put forward and whether it's compatible.
No, I appreciate that. I'm asking for your views on the principle.
But I have to go back a few points to where you started, because you say dealing with the legacy of the Troubles, and this could have been dealt with over the last 28 years, where are we now? But the Troubles were dealt with by Belfast Good Friday Agreement. There were certain commitments made in that. In the ensuing decades, many of these cases have been resolved. So it's not that we went from 1998 to today with nothing happening. The Ballymurphy inquest, for example, moved forward society by a huge amount by just recognising the truth of what happened. And this is not also a situation where people are just absent some information. These were decades when people were told different things opposite to what actually happened. So you can understand the desire. I also understand the desire to, for goodness sake, are we still having to look at this stuff? I live in Belfast now. I want a good future more than anybody. But history tells us this isn't how to do it. You can't just shut it off. You can't say, we need to get on now and forget about it.
No.
But just in terms of when you say dealing with...
Sorry, Miss, with respect, that's not what I said.
No, and I'm coming on to deal with...
What I was saying was that I was referring back to what you had said, and the direct quote is, nothing wrong with what we had before. So is there just no merit in resting the determination of outstanding issues on the evidential thresholds for either court proceedings and or an inquest, without having to have anything else that sits around it?
I think what I said was a little bit more nuanced than that.
With respect, it wasn't, because I actually jotted it down verbatim.
And
the record will show
I did
that
go on to
that's what
talk
you
a
said.
lot about how there were imperfections. Things weren't happening enough. But if we want an analysis of imperfections, some of that was refusal to give disclosure. It was adjournments. It was closed material proceedings. It was PII certificates. Things like that were bogging down the courts and bogging down the inquests. Dealing with the legacy of the Troubles, though, and this is my failing, I'm sure, I don't understand what that means. I do understand as a lawyer what failing to investigate when there's a legal obligation to investigate. I understand what civil claims and inquests and police investigations are. And when I say we had something that worked before, what I mean was these things were capable of being dealt with in the traditional way, worked out over centuries, actually, with all the protections. And what I would also want to say, though, two things just to answer it, because it does... You can't just answer that sort of question with a snappy answer. Stormont House did have support. I'll let my colleagues, if there was something I've missed, it did have a lot of support. This has no support politically in Northern Ireland. So we've gone from some support at least to no support. In terms of veterans and military, I think it's a really important point that's so rarely brought up, because I met quite a few of the veterans and military, some of whom are the victims, many of whom are the victims, and many of whom I met through John Boucher's Canova investigations. They are calling out for independent investigations too. Widows, I met recently, RUC widows, they're calling out for independent investigations. They're not satisfied with this either. They think the state let them down at best, turned away at worst. The other point about veterans and military is, if they may be suspects, what they're getting with ICRIR is not a court process which has been refined over centuries, where the rights of everyone are taken into account and balanced. They're getting something much more akin to the police ombudsman or the HET. And the courts have found problems with that too, because they aren't making proper findings. They aren't being interviewed under caution, for example. So this is something that isn't serving anybody, including veterans and military, and as I say, many of whom are victims in this. And we're not simply talking about state crimes either. We're talking about them, for the most part, we're talking about paramilitary murders and kidnappings and tortures. So it's, I don't think, too often I think people think we're coming at it from a sort of more partisan position, and it really isn't that. But when talking about dealing with the past, that always leaves me, I don't know how to answer that. There is no such thing as dealing with the past. Happened, and there are some things left outstanding that the law says should happen. But aside from that, I don't know what else dealing with the past really means, and I think we often fall into, we also make mistakes by thinking there's some sort of dealing with the past idea. Really, it's loads of unsolved murders, tortures, kidnaps, dead bodies that have never been recovered, state actors who have got away with and may still be here. And finally, sorry, the very, very last thing I would say is this. Article 2 of the European Convention isn't just about investigating the past anyway. It's about learning why it happened, the root cause of why it happened, and stopping it ever happening again. If we don't know why it happened, or why some of the cases happen, we'll never know how to stop them happening again. And there are people still walking around in Northern Ireland today, never been interviewed by the police. So it's that's a much more long-winded, maybe unsatisfactory answer than you were asking for. But it's the only way I can answer in my way that you've asked.
Thank you, Alyson. Just going to bring in David Smith.
I may be preempting some questions I have later, but just on your last reflection there, Ms. Kilpatrick, it seems to me that a lot of this discussion, people are talking past themselves or past each other. Not just in this conversation today, but in many of the other sessions that we've had and the various approaches. And it strikes, just feel free to shoot this down, but it strikes me that at least Mr. Holden, yourself, because of the roles that you have, are very much approaching the issue of dealing with legacy of the Troubles from a legal perspective. You just said you're a lawyer, and that's totally fine and appropriate. And it does seem to me that that's a big part of your critique of ICRA, that the legal system, the judicial system's fine. We've got inquests. We should just be doing that. That is an entirely distinct thing in many ways from the whole process of reconciliation. So I'm not even sure if there's a question here, but I feel I'm sitting here quite frustrated, if I'm totally honest, because I feel like there's an elephant in the room, which is that you're approaching it from a legal perspective, a human rights perspective, which is totally legitimate, but that there are bigger fish to fry in Northern Ireland when it comes to the issue of reconciliation. And I guess in a nutshell, is there a tension between a desire for reconciliation and the role of truth finding in that and the pursuit of justice? Because it seems to me that your passion comes from a place of a pursuit of justice, and you feel like the processes that we've had before are fine, but I guess I'm just pointing out it feels that there's something more needed, and in the kindest understanding of what ICRA is trying to do that other thing as well.
Perhaps I should clarify, and then I'll let Daniel answer that. When I say there was what was there before was perfectly good. I don't say that doesn't mean we can't, that's it. You just never look to whether you can improve situations. That was to make the point that this is new. ICRA is new. This is moving away from centuries of law.
That's exactly my point, that it is new and it's not just a legal process.
No, I know that, but it's founded in law. And the point is that there are legal obligations that have to be discharged. So if you're talking about human rights, there is a legal obligation on the state. ICRA is set up to discharge the state's human rights obligations. That's what ICRA itself says. That's what the police, that's what everyone says. So we've got to look at it as whether it's doing that, whether it is lawful under human rights legislation. I have no... if politics and society can come up with a solution that suits them, if it's lawful, I've nothing more to say. But if it's not, then I have to.
Can I come in, Daniel?
I'm sorry,
beg your pardon.
Article 2 is not just sort of very technical law. Article 2 of the European Convention is about the purpose for it. So it's decided cases over decades which say that it's about learning from the past. So the right to life is meaningless if you don't have a proper investigation, because you'll never stop it happening again. And it's about next of kin, family of the deceased, knowing what happened and people being held to account. So it's not technical. Maybe I explain it in a way that's very arid.
That confirms my understanding.
Yeah. No, but I mean, I probably have to get better at describing it in a more holistic way, but my role is human rights compliance. So.
I just wanted to jump in, if I may, on the back of that, because I suppose when you ask about is something more needed, I suppose I would love to know what more it is that ICRA is doing, because precisely my concern is that beyond these light touch reviews aimed at information recovery, I don't see any evidence of the powers and capacity to get to those broader patterns and themes, the type of work that was envisaged for the Implementation and Reconciliation Group under Stormont House. And I think there's actually a real concern about ICRA's capacity to address the type of thing that I think you're getting at, which goes beyond the legalistic approaches. I don't see any evidence, unless I'm missing something fundamental, in their capacity and powers to go beyond these light touch, and they have linked therefore reconciliation to information recovery, as the Secretary of State put it, to getting answers to families. That's a very, very narrow approach to understanding what reconciliation is or can be. And searching as I have not found the capacity or powers within ICRA's mandate to embrace the broader work. So if we think the information recovery is likely to be limited, and there's reason to think that given the small numbers of victims and families coming forward and so forth, if we think of all of the limitations that have been outlined in terms of the break on the information accruing that they will then potentially be able to publish, what then happens to that? You know, there's no provision to do to join up the dots and to do this work on broader patterns and themes. So I suppose I'm just adding to deepen your concern. I'm not sure that I see in ICRA's mandate the ability to do the something more that you've alluded to. Daniel, I don't know what you...
I suppose my take on your question would be that the approach we're taking and the approach that was taken in Stormont House is very victim-centred, and that's how the various mechanisms were designed. Now, there is an interface with a package of measures, and package of measures was mainly mechanisms that did focus on information recovery, producing information recovery, truth recovery type reports and historical clarification. There were very few criminal justice outcomes of them. But let's remember why we had the package of measures. It wasn't something that just happened. It was something the UK had to agree back in 2004-2005 with the Council of Europe, because the European Court of Human Rights had made adverse findings that there weren't independent and effective investigations, and therefore the UK was breaching its international obligations. That's why the package of measures was put together. And in terms of victim-centred nature, we can't help but draw attention to the fact that families were queuing up to use the package of measures before they were closed down. There were hundreds of cases in each of the mechanisms, dozens in the case of inquests, hundreds in the case of the police ombudsman in terms of the civil courts, many cases within the remit of the legacy investigations branch. And to move towards this sort of light touch review process with a view to controlling the official narrative bends us again to the question of One thing that can be said for certainty about reconciliation is you're not going to get reconciliation where there's concealment and cover-up. That just leads to a very, very poisoned legacy that will not be dealt with, not just for years, but for generations. Within CAJ ourselves and another NGO, victims NGO, the Pat Finucane Centre, a year or so ago when the Legacy Bill, as it was being pushed forward, asked the Human Rights Centre at the University of Oslo to put together an international panel of experts to look at the question of the extent to which there'd been impunity for human rights violations during the Northern Ireland conflict. I have their report here, so it's quite a weighty tome, and it makes a vast number of observations, findings and conclusions. But one recommendation it makes for the future that dovetails into something that both Alyson and Anna had mentioned is there is a missing piece in the whole framework. There's a very important issue for families about individual investigations into outstanding cases. But what they recommended is that be complemented by an international level commission that looks at themes and patterns. That themes and patterns of violations were the missing piece in order to be able to deal with the much broader questions of reconciliation.
Okay. Thanks very much for that. Dan Aldridge.
Thank you all for your contributions. Really value them. It's definitely enhanced my understanding of so much, so I really appreciate it. So the ICRAR model was built around conditional immunity for people coming to it with information. With those provisions now deemed incompatible with the ECHR, how do you envisage participation by and truth recovery from paramilitaries? Anna, could I go to you?
I'm going to actually divert that to Daniel if I may,
cool.
Dan, because he's done some work on this precise issue.
I mean, it's very difficult to see that emerging from the ICR framework. You're right. I mean, Lord Kane, I think, went as far to say, to tell the House that the ICRAR could not possibly function without the immunity scheme. It was entirely built around that. And it's now gone. And what we've now observed, and the UN Human Rights Committee has observed, is there's a very weak mechanism there, whereas what in fact we need really is a mechanism that can do truth recovery with teeth. If paramilitaries, non-state actors are not going to cooperate, you need a robust approach around proper criminal investigations with proper police powers. This is doable. It's been done by Operation Canova. Where you can actually get to the bottom of what happened. You need an effective, independent investigative mechanism that victims trust and victims will go to. And then you will be able to investigate the actions of every perpetrator, but including Republicans and loyalists. The complementary mechanism then in Stormont House was if and when and that mechanism, of course, does not expect perpetrators to volunteer information. It has the powers of arrest, it has the powers of a search, it has the powers of questioning to get in and reach results. Its product, of course, in most cases will not be a criminal justice outcome. I mean, that's pretty universally recognised, given the evidential issues, passage of time and all of that. It will be an information recovery and accountability type report that lets families know just what happened to their loved one. The complementary mechanism was then to be this model based on protected statements in the ICIR cross-border body, whereby individuals could volunteer information, a bit like the Disappeared Commission, in the form of protected statements. That could be non-state actors. Equally, it could be state actors who wish to talk to it and wish to say, look, I witnessed this happened, I want the family to know that this is what happened. So that's the sort of matrix of mechanisms. It's not going to be delivered by the very weak review model of the ICRAR and what it was set up for. It's going to be delivered by going back to a proper, robust investigative mechanism that can get into every set of actors and perpetrators.
Yeah, I can be a lot shorter. I think if I were a paramilitary who'd had 28 years to provide information up to this point and who has, through a number of cases and inquests, tried to be compelled to provide information, I would be asking, why would I do it now? There's nothing to be gained from it. And when I said earlier about it, you can ask for information, you can have every power in the world to ask for information. The real critical power is to compel the information. Why would they come forward? And in the year since ICRR has been going, I don't believe any have come forward. I don't believe anything new has been uncovered. So I just say, what's in it for them? And just purely then go back as a lawyer. If I had a client, I would be advising them that there's nothing to be gained from going. And the immunity was hugely problematic and unlawful. But it was what this was built around, and if that's now gone, why keep the rest?
Thank you. Anna, did you have anything to...
No, I mean, I think it's a good question. I think that we need to think really, really carefully about that aspect of ICR, you know, that is absent, and how you might, but it's incredibly challenging and difficult. For the reasons that have been outlined, it also comes back to this issue of trust, about how you would get interlocutors to engage with this in good faith, how you would verify the information that was coming forward, what the closed statements would look like, what information is going to be made public, how you would support families through that. I think also the sequencing point I alluded to earlier comes back into play. So I do think it's something that needs to be looked at very carefully, and there was good reason why the ICIR was included alongside the HIU in the Stormont House model, to see, because victims, as we know, want different things. Some want to know the detail of what happened to their loved ones. They don't perhaps necessarily want to go down the route of investigations, and it's important to give choice, but it's extremely challenging, and I think it's not easy to develop a truth recovery process around this. But yeah, I think a lot of good work was. I mean, back to your question earlier about, you know, why would we scrap this and start? A lot of the heavy lifting on this work has already been done, and is there to be revisited if we move away from the ICRA model towards the type of model that has been considered at length and has the support of victims.
Thanks, Anna. There's just a more specific supplementary for Alyson, if that's okay. So should the list of those who can refer cases to ICRIR be widened as part of its reforms, and should the Commission be able to initiate their own investigations?
In my view, yes to both of those, but it doesn't cure if you keep the ICRIR as it is. So having more people able to refer into a body that is, as I say, fundamentally flawed, isn't going to help. But if you're setting up a body like the HIU, then having other references in would be important.
Okay, Katrina Murray.
Yeah, thank you all for the contributions you've made so far. Now, all of you have talked about the positivity of the Operation Canova process, both within your written evidence and with what you've said today. If that was to be translated or to be carried forward into the government, into what the government will do next, what lessons should they be learning from Canova? I'm
the person who's probably seen it
probably
most from the inside, so maybe if I start. I think what you have to remember is that Canova was a criminal investigation. It was called in by the PSNI because they were not, in their own view, sufficiently independent to do it. Mm-hmm. So it is simply a criminal investigation, that's what it was. But what was different was that there was a truly independent team with no former RUC or PSNI background. What was different was that they were expressly tasked with looking at the sort of theme overall, trying to link all these various different incidents. Because they were an independent investigation, they had the scope to go wherever the evidence took them. They had the power to compel evidence, arrest, interview under caution, etc., send files to the PPS. But I think ultimately the difference was that John Boucher, who was appointed, before he did a thing, he took advice on the human rights framework that he had to set up his investigations around. He spoke to every single person that was involved in his investigations. He instilled confidence and trust. He told them stuff. He explained every single thing he was doing. He told them in advance what he was doing, who he might be, within reason, the sort of stuff he could tell them. And he created such confidence and trust that people who had refused to speak to the police for decades shared information with him. Because of that, because they came forward with information and new people came forward with information, he got more information than anybody else has ever got. But just in terms of, and what's the difference between Canova and one other thing that he ended up taking on, which was Glenanne series of cases, which was known as the Glenanne gang. Maybe it was a gang of, I won't go into the details of that, but that wasn't a criminal investigation, but he was asked to take it on as a review. Because it was a review, he was unable to require information cross-border from An Garda Síochána, and there had to be a lot of very sort of clever legal stepping and statutory orders and things put in place to enable him to compel information. I saw that as being one of the key differences. If you want proof of what a criminal investigation can achieve as a truly independent, properly minded person, and a review, even by that properly minded person, so he got information on one and he didn't on the other, and Glenanne is still going through trying to get information, and so it started off with the right appointment, and he started off with the right approach, and he went to those people most affected. He also instilled trust in serving and ex-officers who felt that they were going to be hung out to dry with these sorts of things. So it's, it can be done, but he had the trust. He built the trust. Once it's lost, I don't know where you go from there.
So I had three things really. The first one is, and a lot of them echo and overlap what Alyson has said. First one is the building of relationships and trust that the approach Canova took, and the contrast with that in the ACRAR. The second one relates to the practical independence issues, and the third to the investigative model. So Canova, when it was first set up, there was a lot of mistrust, distrust, suspicion. But the approach they took of building relationships, of being something that people could trust, being something that key independent people could trust, that could then be brought in to independently assess what Canova was doing in a credible way, in order to allow others to have the confidence to engage with it. And with very hard to reach and diverse communities and constituencies, they did that incredibly well. The contrast with the ACAR could not be starker, which their approach has been characterised by sort of hubris and not humility. It's more of an approach of, well, we're here whether you like it or not. Canova, when there was criticism, always engaged constructively with that and sought to deal with it and accommodate legitimate concerns. The approach of the ACRAR has been to lash out at anyone who criticises it, to the extreme of having a leaflet on its website called Myths and Facts about the ACAR. Well, it misrepresented the court ruling, misrepresented the position of the Council of Europe, and generally said that people who were criticising it had got it all entirely wrong. Now, to be fair, the Secretary of State did intervene, and they've now removed that particular leaflet from their website, not least because it misrepresented the Court of Appeal's findings around the ACRAR not being able to conduct ECHR-compatible legislation. But the approach that ICRA have taken so it's not just the Legacy Act, the toxicity of the Legacy Act, it's ICRA's own conduct since it was established, has irreparably damaged trust in a way that Canova has demonstrated that they managed to build trust with a lot of the same constituencies. The second issue then that Alyson's also outlined is practical independence. Canova took the decision that it had to exclude for practical independence reasons former IUC officers and former military officers, exactly the same approach as taken by the police ombudsman. One of the package of measures did not take that approach, which was the PSNI Historical Inquiries Team. And as a result, after a very damning inspection by Her Majesty's Inspectorate of Constabulary, as it was then called, the HET had to be closed down precisely for that reason. HMIC held that you could not have IUC officers in those positions if you were going to afford practical independence of legacy investigations. Now, in some part, the legislation has pushed ICRA in that direction, but it didn't necessarily have to. The legislation requires that a proportion of investigators have previous Northern Ireland policing experience. However, that policing experience could have been drawn from the Canova investigators moving over could have been drawn from the Ombudsman, rather than the most recent figures as they've employed 10 RUC officers, which just on a self-declaration model of conflicts of interest, exactly the same model that was criticised by HMIC in relation to the HET. We've just history repeating itself there with a lack of practical independence. That was never a problem for Canova. It managed to deliver that. And then the final point is the robustness of the investigative model of Canova. Using full police powers, the ACRAR has only used its police powers once so far, with the on the latest figures we've got from them. That was the referral from, I think, from the Secretary of State. It's never used powers of arrest, etc. Canova used its police powers really well to gather evidence and construct very, very robust and detailed reports. But above all, Canova knew that agents of the state were not above the law. And that's very much the approach that it took. That doesn't mean revealing the names of state agents that were involved in lawful activity, but where state agents were involved in human rights violations, killings, torture, kidnappings, other actions, they are not above the law and they are not above investigations. And Canova made sure that individuals in that situation were investigated. And that is referenced in its final report because Canova was not subject to a national security veto in the same way as built into the Legacy Act for the ACRAR. The contrast could not be starker.
Yeah, I mean, I'd not add too much to what has already been said. I think I'm minded of, I think it was Seamus Heaney said that anyone with any gumption when judging a person or a thing will look at two things: what's said and what's done. What's done in terms of the practical independence, in terms of the powers being used to get information to families to desist from cover-ups and so on, is all the important what's done. The other part of it, I think, speaks to the interpersonal trust, and Alyson alluded to that, to the heavy lifting that was done in terms of winning trust of families. And I think, as we all know, that is an incredibly slow and delicate process. It takes an awful long time. And I know this just from my own oral history research. I've interviewed hundreds of people, former security force personnel, former prison officers, former paramilitaries. Building up trust on those sensitive projects takes years, but it can be lost in a heartbeat. So I think Boucher was alive to all of that, but it was the approach, it was listening, it was patience, but it was also the practical independence and the delivery.
Thank you. I do have two quick questions because I know we have to hard finish at 11:15. Are there any people that worked on Canova now working at ICRA, Alyson?
I'm aware of one.
One?
Yeah.
Okay.
But I don't know all the individuals.
Okay.
I'm aware of one senior Canova person who moved over to ICRA.
Okay, thank you. And Daniel, the leaflet you spoke about, yes, you're correct, it has been removed. Would you have a copy you'd be able to send us?
I certainly would.
Thank you very much. Moving on to Claire.
Thank you very much, and we are pressed for time. I think the core thing that's running through everything we're discussing today is about the suppression of information, and there is a sense that there's all this complicated architecture and all these different legal processes, but that they exist because the people who made victims, state and non-state actors, are suppressing the information. And I think, Alyson, you expressed that very well, and the bits that have been allowed to work have worked. Inquests were getting to truth, and the reason they maybe took longer is because they weren't funded, or layers of information weren't disclosed. And I think similarly with Canova, and there is a myth that, well, nothing's working, so we have to bin everything when we're failing to lose the lessons from things like that. What is the core thing that the committee need to understand, do you think, about disclosure and about removing vetoes? For example, what was in Stormont House on that? And I unfortunately, you need to give us the edited highlights of it. And secondly, you might comment just on what the failure to address this properly, get the legal processes in place, have some sort of shared way to memorialise. What's all that doing to the rule of law in the present day?
Well, you have to start off from the premise that we are a rule of law society. We are bound by Article 2 of the ECHR and Article 3 of the ECHR. There are investigations which never happened, or which happened in a way that wasn't compliant with the rule of law. Those people are still left without answers to, as I said, murder, rape, torture, all sorts of horror that happened. So you have to start from the basis that you live up to your obligations and find a way of discharging your obligations. You don't say, these obligations are becoming, there are too many of them, it's tiresome, it's too expensive. we're going to hide behind our own wrongdoing of delaying for 28 years the answers coming out, and now say it's too late for the answers to come out, or it's too expensive to get the answers. So I think that's where you need to start it from. You need to sort of flip this right on its head. What is actually required legally? What is required morally? What does society expect? And what does the rule of law really mean? Rule of law does not mean that those who are strong get to determine it. It means those who are weak get to be protected. And I think that's often understood as well. But in this case, that means discharging legal obligations first and foremost. You could put money into, some of the money that's going into ICRA, you could put back into an inquest, coronial system. So Declan Morgan said he could have cleared the inquest in 5 years, some years ago, if he was given some money. So what was the other point about the storm at the house? I think Daniel might...
I suppose, and it was basically those, what core things do, I suppose, we need to know about disclosure, what mechanisms were in
Disclosure is everything. Disclosure is
Yeah.
everything, because what partial disclosure over all those years resulted in was falsehoods coming out. Some people being told their loved ones were terrorists and were shot because they were trying to shoot soldiers or police, for example. That has continued for decades, with people being told that and having to live with that. That in itself creates a fracture in society and a lack of trust. So you have to start by understanding why the information is needed for them, but also I didn't lose anybody during the conflict, but as a member of society who believes in the rule of law, I think I want to know the information about what the state did
ugly and all
or
it's
didn't
going
do.
to be.
Yes. So it's not just about the victims and the families, but they must be at the centre of it. And I think the ability to suppress disclosure of information. I can't say it any better than John Boucher gave a speech, British Irish. I think he's appended it here. That speech said everything you need to know about it. He was horrified by some of what he saw, but he was head of undercover policing for a long time. This is not a behind the ears human rights sort of advocate. He was horrified by what he saw, and he said the only way you get over this is to get it all out there. He only got it out there because he didn't have a veto. There wasn't a veto against him. But even with that, he still struggled. So you need every power at your disposal.
Yeah, if you can't. Yeah, Daniel, I just am aware we've got minutes.
The Court of Appeal has found that the national security veto over the ACRAR is unlawful. And that's not surprising. I mean, it's a power for ministers to essentially redact out information from the reports of what is to be an independent body, and it's any information that relates to the UK's national security interests, a concept that isn't defined, or any information that emanates from the security and intelligence services, IUC Special Branch Military Intelligence, etc. And what we all know this is about is essentially trying to exclude from reports, trying to conceal human rights violations that were conducted by state agents, either the toleration, facilitation or direction of state agents within paramilitary groups to conduct very serious crimes, up to and including murder. I know you won't be able to see this much from here, but in our November report, we did a thing whereby, and we've done this before, we took the first page of the Police Ombudsman's report into the Loughlin Island massacre. That's what it looks like in the Police Ombudsman's report. And we redacted it in a way that it could be redacted had the national security veto been in place. About 3/4 of the page disappears as a result of the national security veto. All the stuff on weapons importations, all of it based on intelligence information and the actions of agents. So in terms of core messaging, Claire, I think, and we're deeply concerned that government has decided to appeal that element of the Court of Appeal ruling. In terms of core messaging, I think I'd say there is no case for a national security veto. No. There has not been, setting aside the issues that we could debate on another day with the Inquiries Act, for the rest of the package of measures and Northern Ireland legacy investigations, for the last quarter of a century, there has not been a national security veto. There was no national security veto over inquests, none of this form, none over the Ombudsman, none over Canova, none over any of the other types of investigations, none over civil court proceedings. So why would there be a case to introduce one now when there hasn't been one for over a quarter of a century?
Thank you.
That's what John Boucher says in his speech, and he gave that speech as Chief Constable of the PSNI. and he repeated it then. What makes us safer is getting this out, no veto, and he was absolutely adamant about it.
No, I was just going to add that I think it touches on the bit that we probably won't have time to get into, which is what is the purpose of Part 4, because Daniel alluded to, well, why do we have this? And it is about controlling the narrative of the past, what was often referred to as stopping the rewriting of history. And I think it was Brandon Lewis, Secretary of State at the time, when explaining that, said that is why we will also set up a major oral history archive. We will also set up an official history, as it was termed at that point. And I suspect we won't have time to get into that today, but I would really be grateful if members have any information they can share with us as to what is happening in that particular space, what is planned for Part 4 of the Act. But motivation is obviously one of the key concerns, and it flows from what has just been said about the national security veto and why it was introduced.
Okay, just with an eye on the time, I'm just going to finish off with David Smith.
I'll take 30 seconds and you've got whatever's left. You don't have confidence in the information recovery function of ICRA, and you want something old, not new, something that's been... Reconciliation should be taken out of the architecture of ICRA, that's what I'm hearing. So does that leave us with a judicial and legal process with an indefinite end as our way to deal with the legacy of the Troubles?
That's for Anna.
Sorry, say it again, Dave. Did you say reconciliation should be taken out?
I'm hearing that's what's been said. So my question is, does that leave us, if it is, and if we have something like a historical investigations team, does that leave us with a judicial and legal process with an indefinite end as our way to deal with the legacy of the Troubles?
Well, I mean, it's not so much about taking reconciliation. I think reconciliation needs to be defined and it needs to be front and centre. My problem is not that their failure, it's just the lack of clarity, the lack of conceptual clarity that Alyson mentioned at the minute that is going to bedevil, what flows from that. I don't think it is. I mean, it is going to be a long process. You don't solve 40 years of conflict, or hundreds of years of conflict, if you want to go further back in a short while. It is going to, the process of real reconciliation is going to take time, right? But you have to adhere to the rule of law, provide victims with the right to truth, with the right to effective investigations. And if you get that right, the space then opens up, I think, to develop mechanisms alongside that speak to the patterns and themes that Daniel talked about, to engage historians in broadening out this work beyond that which the courts can accommodate, or that which more narrowly framed investigations can accommodate. But this brings us all back to the fundamental issue of trust. If you have trust in the bona fides and the motivation of what is being set up, and and where it's where we want to ultimately get to, however elusive that idea might sometimes seem. If we're agreed on where we want to get to, then I don't think we just throw our hands up in the air and say it's just impossible. It is quite possible to have these things running in parallel, albeit progressing, at different paces at different times. We talked in our evidence about thicker and thinner reconciliation. You often have periods of thin reconciliation, which speaks to what Mr. Hoare was talking about, not drawing a hard and fast line onto the past, but being more forward-facing. But it has to have aspects and elements of the thicker reconciliation that we delineated if you're going to avoid intergenerational trauma, which we haven't touched on, as one of the offshoots of taking that narrower approach. That's a little bit long-winded. I do apologise.
Sorry to stop you there, but can I say thank you very much. We will have additional questions that we'll be writing to you about. So thank you, Anna. Thank you, Alyson. Thank you, Daniel. Order.